А це буде окремий відеозапис, так? Ні, просто вирішу маленький. Добрий ранок, шановні колеги.
Good morning, dear colleagues. The Commission, before we start today's interviews, has to make a short announcement which is related to the candidate for the HQCJ, Judge Shevchuk. The point is that during the interview with him, when giving answers to one of the questions of the commissioners about the property located in the occupied territory, some personal information was disclosed, and it was after the interview that the candidate asked to eliminate information about the specific answer, in particular the part dealing with personal data disclosure. He asked us to close this part of the interview. The Commission has granted the motion. Now there is no interview with him on YouTube. We will work with technical issues to remove the short part related to personal data disclosure. And then we will have the interview back, but without this personal data. That's it. Thank you.
Вітаємо вас.
Welcome. Good morning, dear members of the Commission.
Вітаємо вас на другому етапі конкурсного відбору до Вищої
Welcome at the second stage of selection to the HQCJ, the interview stage. The interview
конкурсна комісія проводить в повному складі.
Is conducted by the full composition of the Commission. These are Tad Zazhechny, me, Ivan Mishchenko, Serhiy Verlanov, Ivan Miesan, Steven Markman, and Robert Bruheisen. The reporters at your interview are Tad Zazhechny and Serhiy Verlanov. If our interview is interrupted for technical reasons, we will reschedule it. Of course, we will communicate on this with you. The interview includes the Q&A session, and the commissioners will ask you questions. The request is to provide concise answers to the core of the matter, and the commission asking the question maybe shall be entitled to limit you in terms of the duration of your answer, time of your answer. Before the interview, you will have a chance to tell about your motivation as to why you have decided to apply for this position, and to tell about the ideas you have got about the work of the HQCJ and probably about the judiciary in general. With this, let me give the floor to my colleagues. Tad, Serhiy, you're welcome.
Good morning, Judge Shevchuk. Before we begin with certain questions of you, Judge Shevchuk, I want to give our viewers a little bit of personal background about you. You are 58 years of age. You were born in the Lviv region of Ukraine. You began your professional career in the law as a legal advisor from 1988 to 1993, and then you were appointed in 1993 as a judge of the Kremenets District Court in Ukraine. You served on that court, which is a court of first instance, for 9 years, and thereafter you were appointed a judge of the Court of Appeal of the Ternopil region, where you served for another 20 years. And in 2018, until the present time, you are a judge of the Ternopil Court of Appeal. Your experience in the field of law is 33 years and 11 months, and you have been in the position of a judge for 29 years and 3 months, and you are currently married. That's a very brief introduction of you. Judge Shevchuk, I am now going to turn the floor and the microphone over to you. You can tell us a little bit more about yourself if you care to do so, and as well a little bit of your motivation for having applied for appointment to the High Qualification Commission of Judges. So the floor is yours.
Good morning, dear commissioners. I'm Halyna Shevchuk. I'm the judge of Ternopil Appellate Court. Just in brief, I will tell you about myself. So in 1988, I graduated from Lviv State University, named after Ivan Franko, and the specialty was law. Since 1993, as you have mentioned, I work in the Court of Trial instance, and for 9 years I was considering civil criminal cases and cases on administrative offenses. In 2002, I was appointed judge of Appellate Court of Ternopil region for civil matters. In 2020, I was elected to deal with, within this court, with some civil cases, and in my activity, I base my actions on the rule of law. Ukraine has launched the process of reloading of the judiciary because the level of trust in the judiciary was very high. Implementation of the judicial reform became a priority for the whole country. And I think that it is important that civil society wants the transparent system of judicial selection and assessment of judges. And it was for the first time that the PIC was established, it including the representatives of civil society organizations. And the goal of the PIC is to help with determination of the criteria of ethics for judicial candidates and incumbent judges. I was very positive about this innovation in terms of publicity of judicial assessment and beginning of the judicial reform. And I participated in the first public selection for the Cassation Civil Court affiliated with the Supreme Court in 2016 and 2017. I passed all the selection processes, and there was no negative opinion coming from the PIC for me. My motivation to participate in today's selection process is as follows. I want to, and I actually strive for, completion of the full-fledged judicial reform, which will accelerate revival of public trust in the judiciary. For 30 years in my life, I worked as a judge, and it's important for me that the judiciary has people of integrity, professionally competent, independent judges who will increase the level of trust in the judiciary. In Ukraine, assessment has not been completed for more than 2,000 judges, and there are a lot of judicial vacancies in place. Both the judiciary and the society are in need of quick and systemic steps in order to fill this increasing and growing number of vacancies in appellate courts and courts of trial instance. And it would be useful to change the sequence of steps within the procedure of selection, to reconsider the timeline of training of judges. But of course, this should not affect the quality. We should also consider the option of having remote testing. We should involve the PIC in the selection more. And these conclusions, the opinions of the PIC, should be binding. I mean, they should be obligatory for it being taken into account. And I think that the HQCJ and the PIC should act as partners within the process of selection and assessment of judges. They should cooperate actively in order to establish professional judicial system. Thank you for your attention.
Well, and thank you for your introduction and your introductory comments. As you know, Judge Shevchuk, we now proceed to ask you questions that are revealed by some of the information that we have been provided and collected with respect to your career. That includes, of course, the reports of NABU and the NACP, as well as the reports from civil society. And there were a few property issues and questions were asked of you, and you provided written responses to those questions. However, I will leave that to my colleague, Judge Mizentsev, to deal with, and I will deal with certain other matters, including general matters.
It's Verlanov.
Yes, I know.
You told Mizentsev, but it's Verlanov.
Yeah.
Mizentsev is an asset expert.
Yes. No. So, after our little discussion, let's resume. I have one or two questions, and it actually deals with the point that you shared with us in your introductory remarks. You did tell us that you were a candidate in 2016-2017 for the constitution of the new Supreme Court of Ukraine, and you were approved as being competent to provide those services. That, of course, involved the former High Qualification Commission for Judges of Ukraine. And I would be interested in your comments with respect to your personal views as to the process that the HQCJ used to review your candidacy for the Supreme Court and others, and the procedures. And I would be pleased to have you share with us what you thought was good about their process and what was not so good, and changes that you would make if you are appointed a member of the HQCJ.
Thank you for the question. Well, I really was a candidate for the Supreme Court in 2016 and 2017, and I really passed all the selection stages. Both civil society and European experts recognized that the selection for the Supreme Court was transparent, and civil society also said that they trusted in this selection procedure, in that contest. All the selection procedures were rather good. I can't tell that they were not transparent. They were transparent, they were of high quality. And the main thing we should probably pay attention to in those selection procedures, some room for perfection, is test items on the knowledge of the law. They were too detailed in terms of dates that just need to be memorized. And, well, that was the opinion expressed by a lot of candidates who were passing that assessment. They said that actually these test items could reflect knowledge of the law and no dates, because simple dates are not an illustrative thing, and sometimes the candidates gave the wrong answers because it was difficult to memorize so many dates. The main thing in the activity of the HQCJ of the previous composition that was negative was the fact that the opinions of the Public Integrity Council, when rejected, were just rejected and not taken into account at all. And the motivation was not taken into account. The reasoning was not taken into account. Because it would be necessary actually to provide the reasoning why this negative opinion has not been accepted. And that led to kind of the opposition between the HQCJ and civil society organizations. And I think that this has a negative impact and negative comments from the civil society. The civil society was dissatisfied at the result of that and actually had reasonable grounds for that. Because all the opinions of the HQCJ should be well-grounded, reasoned. That's why in the work of the future HQCJ, we should definitely take into account all those things. And all conclusions, all opinions of the HQCJ should have proper reasoning. And this procedure of involvement of the PAC in the work of the HQCJ should be well coordinated. The schedule of work, the schedule of opinion provision, this should all be clear, and the candidate should get the opportunity to give all answers. So this was a minor flaw in the selection procedure. Thank you.
Yes, thank you very much for your answer. Let me turn a little bit to an issue that has arisen with respect to your judicial activity. This is a situation, as you are aware, that raised concerns in your handling of a case in 2015 until 2017. We are informed by our sources that your husband worked and received a salary at Agro-Prod-Service Corporation. It is an agro-industrial enterprise. As a judge, you passed judgments in cases in which your husband's company was a party. We are told that there were 18 such decisions, most of them being procedural rulings. However, in a case decided in 2017, you denied leaving an appeal from a trial court judgment, and that decision was a decision on the merits of the case and was in favor of your husband's company. You returned the case for new consideration to the court of first level. Now, the concern that is raised here is the question of partiality or impartiality. As you know, that is a cornerstone, one of a number of fundamental principles that apply to all judges. And the issue raised by these circumstances is whether or not you ought to have recused yourself from considering cases in which your husband's company had a financial interest, and that as a result, of course, the impact on the company would also potentially be an impact upon your husband. In considering these circumstances, do you now feel that it would have been a better approach to have recused yourself from consideration of any cases involving your husband's company? And if not, could you please explain why not?
Thank you for the question. Let me provide a wider picture of this issue. My husband really worked as deputy CEO of private agro-industrial company. And beside my husband, there were 6 more deputy CEOs in that company. And you can have a look at his work record. His duties included communication and connections with territorial communities, which means that he had nothing to do with conclusion of agreements, any commercial activity, coordination of work, of the methodological work, or he didn't deal with representation of interests in court, and he didn't have the right of signature. He was just an ordinary staff member of that company. That's why when I got this case into my consideration in 2017, and I was the chairman in this case, then during the court hearing, because we have open public court hearings with the hearings being recorded, so for the parties and for the public not to have any doubts concerning my impartiality, I disclosed the information during the court hearing saying that my husband is an employee of that company. And the claimant in the case didn't have any objections. That's why I did not announce any self-recusal. There is a video record, audio record of this case hearing, so actually it's possible to check this. And the case was revised by the Supreme Court, and the decision was remained in effect. Was left in effect. Also, let me explain you that Ternopil region is the region of agricultural activity, and we have a lot of cases like this. And as you have mentioned, there have been 18 in relation to this company, but that was just the beginning. There could be 100, there could be even more cases. And that's why the issue of self-recusal could be perceived as ungrounded self-recusal, because then it would mean that I would have a lot of self-recusals. The person with the record number of self-recusals in the country. So the Council of Judges thought that there was no need for such things, self-recusals. Also, there was another case which I considered in 2018, and I was within a joint panel of judges, but I was not the chairman. And there was also an audio record, and the chairman in the case disclosed information about the fact that my husband is the employee of that company, but he is not owner, he doesn't have assets in that company, just an ordinary hired staff member. So no recusal was made. As far as procedural issues are concerned and procedural decisions, which you mentioned, these were mostly written proceedings, and we didn't call the parties to the court hearing. These were really procedural issues, and in these 18 cases, decisions were mostly not in favor of the company where my husband works, because we actually gave the writs back to the claimant because some formal issues were identified in those cases, and then the resolutions, the judgments were cancelled and they were sent for revision. So this means that these 18 procedural cases were not in favor of the company, which shows that I was not partial. I was impartial in the consideration of these cases. That's all for me. Thank you. Maybe you've got some further questions.
Well, I do in this respect, Judge Shevchuk. There is not an issue that arises with respect to how these cases were decided. No one is suggesting that you provided favor to your husband's employer. That's not the issue. The issue is whether or not, insofar as public confidence in the judiciary is concerned, whether or not you have an obligation to recuse yourself whenever the financial interests of your husband's employer are raised or involved. Whether it's one case or 100 cases, the principle is the same, and the issue deals with the appropriateness of a judge hearing cases involving an immediate relative's employer that may have financial implications for that party and consequently perhaps the employment of your husband. Do you see things differently now, or if a case arose tomorrow involving your husband's company, would you recuse yourself or not?
Well, because of the issues that the civil society organizations have voiced, I would now probably make a self-recusal, because back then I didn't have doubt about this, since we have the agricultural region and cases with agricultural companies are plenty, are numerous, or suppose there are some companies provided services to each other, or there are issues of sublease which are only close to agricultural issues. But now, well, I was impartial, but now I would announce self-recusal because I know about the response of civil society.
Thank you very much. I will now ask my co-rapporteur, Judge Verlanov, to ask you questions he may have.
Дякую, пан Тед. Доброго дня, пані Галино.
Thank you, Ted, and good morning, Halyna.
Тепер у мене буде до вас ряд запитань.
I will have a number of questions to
Скажіть, будь
you.
ласка, в своєму
In your
мотиваційному
motivation
листі
letter,
ви серед своїх якісних
among
переваг
your
зазначаєте,
quality
зокрема,
characteristics,
що ви
and
вмієте
you claim that you
безконфліктно
know
взаємодіяти з
how
колегами.
to interact with your
Поясніть,
colleagues,
будь ласка,
having no
чому така,
conflicts.
риса,
Can such characteristics you have, to which you refer in the motivation letter, have a negative impact on your principled nature in advocating your own standpoints? I mean, that if you have to choose between advocating your point of view and preservation of a good atmosphere in the staff, with other staff members, what will you choose? Thank you for the question. I will always keep advocating my point of view, but when I said that without any conflict, I meant that within the moral principle, I will do this within the moral principles I have to follow. So you have to be clear and impartial in advocating and grounding your opinion. That should be just advocating the opinion and not correlating or having a conflict where you are trying to advocate your opinion.
Зрозуміло. Тепер
Clear,
продовження.
thank you. So you should be firm in your position, but that doesn't mean that you should have conflicts.
Тепер
These are
наступне.
different things.
Знову ж таки, в
Clear.
своєму ж мотиваційному
Again, in
листі,
your motivation
ви
letter,
вказуєте про те, що
you
готові
say
працювати в команді
that you're ready to
однодумців,
work in a team of like-minded people
щодо реальних змін судової
in order to
системи на
introduce
краще. От тепер
real
я хотів би
changes
запитати
into
у
the
вас,
judiciary
у
for the
випадку,
better.
якщо у
And in
колег будуть
case
не
your
вашими
colleagues
однодумцями при
are
прийнятті
not
рішень, як ви будете
like-minded
діяти?
people, how will you act while decision needs to be
Як ви
passed?
зможете працювати тоді
How
в
will you
такому
work
колективі?
with such people? How will you cooperate and interact with them? Well, like-minded people, well, thank you for the question. In my motivation letter, well, when I expressed this idea that I would like to work in a team of like-minded people, I thought that, and I think that the team of like-minded people are generally the people who will work in the HQCJ. They must be set for positive changes and reform and selection of people of integrity and improvement of the Ukrainian judiciary. The main goal is revival of trust, public trust in the judiciary.
А, ви в такому ключі маєте на увазі.
And that's
Зрозуміло.
what I mean. Okay.
Зрозуміло.
But if we have any misunderstanding in some issues, everyone should set out his or her opinion, and then you can reach some decision. It's just a normal process because the truth is born in the discussion of those issues.
Добре. Тепер наступне запитання в продовження
And here is the next question
того,
to
що ви
continue
бажаєте змінювати судову систему на
with you,
краще.
the changes in the
Що ви
judiciary. You claim
вважаєте,
that you want to
що
change the
погано зараз
judiciary
в
for the
судовій
better. But
системі?
what
От
do you
з
think the
урахуванням
problems in the
вашого
judiciary
багаторічного
right now
досвіду
are?
в судовій
You have
судовій
many
роботі.
years of
Що ви вважаєте
experience of working in
безпосередньо,
the
конкретно такі от,
judiciary. So
ваші
what do you think are the
приклади, які
drawbacks
можуть свідчити про
in
те,
the
що дійсно
system
погано в
that can
судовій
really
системі?
show that the judiciary is not yet that good? Thank you for the question.
Якщо громадянське суспільство висловлює
In case civil society expresses distrust in the judiciary, and we can see this from the surveys, the level of trust is very low in the judiciary. And definitely this means that the judiciary must be changed. You know, civil society is positive about changes. For example, positive about the anti-corruption court, which was established, and civil society considers this change, this establishment to be a positive thing. The same goes for the establishment of the Supreme Court. It has been received positively by the civil society because of the transparency of that selection. The selection for the High Anti-Corruption Court also was transparent because it involved foreign experts, and the trust in that court is very high. That's why if the overall trust in the judiciary is low, we need changes. And
зараз в даний час є
now
спочатку великі
we have a lot of vacancies in the judiciary, as I've already mentioned. And these several problems together lead to delays in case hearing. It leads to the situation when people actually don't have good access to justice. But the judiciary needs to be filled with judges who are men of integrity, following new criteria the civil society requires to set. And the task of the HQCJ is to select new people with new vision to upgrade the judiciary. And of course, as a result of such objective and transparent selection, judges will work in an adequate way. I can't tell that the judiciary is not working, it's not operating now. In particular, we can see that even under martial law in the wartime, courts still keep functioning and try to ensure access to justice. But of course, courts need to be improved.
Добре, дякую вам, пане Галино. Зараз я
Good.
передаю
Thank you,
слово пану
Halyna.
Роберту.
Let me give the floor to Robert.
Thank you. Good morning, Mr. Jeff. When I've read your motivation letter and the information received, I'm always wondering why you think that we would be selecting a judge who has 30 years of experience in the judiciary to be part of the reform, because reform means it is different from the past, and you have been a part of the past for a very long time. Why would we select you?
Yes, sure. Thank you for the question. As I already mentioned, I started working in the judiciary in 1993, which means that actually I started working there when Ukraine became independent. And over this period of time, and actually all my life long, I've been working at the improvement of the reputation of the authorities, of the judicial system. And I think that my life path and my career path really do prove that my work was not in vain, and that my work shows that I've been trying to increase the level of trust in the judiciary, public trust in the judiciary. At least I think that I have not contributed to the deterioration of the situation.
Okay, thank you. When I look at your assets, I see someone, and first the question, what kind of a car are you driving at present?
Наша родина
Well, our family has Volkswagen Polo. We bought it 6 years ago.
Yeah, I saw that. I saw that, and there was also another car. Huh? I saw what was it again? A Hyundai or something.
There is no other car.
It's only the Volkswagen Polo. So what strikes me, but what I find special, is that if I look at you, you have an apartment. Let me see what my assistant says to me. No luxury car, only one apartment, $20,000 in cash savings. If I compare you with other judges, the question is, what did you do with all your money? Because you seem to be living an ordinary life. You don't have a Mercedes 350. You don't have 25 land plots. You don't have all kinds of other buildings. How is it possible you don't have that?
Дякую за запитання.
Thank you for the question.
Я, звичайно, живу
Well, of course, I do live as an ordinary citizen because the salary of judges, and you can see this by the declarations,
90-го, коли я почала
in the 90s, to be more specific, in 1993, was $8. And that's what the period when I started working in the position of the judge. And I started getting my salary, which was already a bit higher, in 2017, when I passed
кваліфікаційне
the qualification assessment.
зараховано моє проходження, мій конкурс.
When I completed qualification assessment after the competition for their Supreme Court, I was acknowledged to be the judge who can really administer justice in a cassation court.
Yeah, I've seen that.
2017 року зарплата стала більшою.
And then my salary became higher. But before that, I didn't have high salary. And that's the reason for all this.
Yeah, but
why I
if
have just some
if I may
minor
interrupt you,
savings.
but I've seen many colleagues of you applying for this important job, who have been able to acquire a quite substantial amount of assets. And of course, you will note sometimes that other judges, they drive to court in very big cars and have beautiful houses, etc. What is the reason of that, you think?
Кожному дякую за запитання. Я
Well, thank you for the question.
конкретно
I think that in every specific case,
кожними активами за
behind every specific asset or property item, there is a surname, a person.
Yeah, I understand that, of course. That
йшло спадок, комусь спадок, комусь так. Я не
Well, I think, I don't know. But if there are some facts of illegal enrichment, they should be investigated. And that's the only thing I can tell.
but this is exactly the point. You have on paper limited assets. I see many people who have quite substantial assets, and people who also show off their wealth by driving big cars and having big houses. And you haven't, and you tell me that you've just been spending your money on ordinary living. And is this not the basis of the trust of the judiciary also? Except that there are not only they're not sufficient judges, but also this fact. Is that not part of the lack of trust in the judiciary? The reason of the lack of trust? And what are you going to do about it?
Ну, фактично, політична заангажованість
Well, political engagement of a part
частини судової системи
of a part of the judiciary and illegal enrichment are the two problems that have led to this lack of public trust in the judiciary. And well, what I would do, if I've got your question right, in case you mean what I would do if I am elected a member of the HQCJ?
Well, it's two things. You must have seen this, let's say, many, many times, that you drive to court in your old Polo and that other judges arrive in a Mercedes 350. You should have thought about yourself, how is this possible? Or is this the first time the thought comes up now with you?
Якщо доходи законні,
Well, if the income is legal, we can't have any claims.
якщо доходи законні,
But if the income is really legal and the person, well, maybe the wife of the or the husband of the judge has some business, is a businessman.
They all have, of course, they all have mother-in-laws. We know that. The question is, did ever the thought come up that this is a problem? Because if the thought never came up, yeah, I would ask myself the question, are you someone to be elected in the HQCJ? Because then this is an obvious thing, isn't it?
звичайно, виникає ця думка не тільки в мене.
Well, of course, I have had this idea. I've thought about it. Not only me, but the public has thought about that. But that is the issue for law enforcement bodies. If the income is legal, a person is allowed still to have this car and to live in the apartment she likes. But when the income is ungrounded, illegal, then the law enforcement body should respond.
Okay, thank you. I will pass the floor to my colleague.
Скромно.
But generally, a judge should be living a modest life. And even if there is a car which is expensive and he can buy this car, it doesn't mean that he should come to his workplace by this car.
Now it is Mr. Justice Markman's turn, I guess.
Thank you very much. Thank you for being here, Judge Shevchuk, and for your participation. I'd like to start off with a similar question to my colleague, Mr. Brookhuizen. You have been on the judiciary for 30 years. That's very, very impressive experience. And I know there are people who've been on the judiciary for 30 years who can be reformers, and there are people who've been on the judiciary for 6 months who might not be reformers. Could you just focus me and the Commission on what is the most important evidence or aspect of your history on the court that suggests that Judge Shevchuk is a reformer? Not words, because everybody has good words in this competition, and you do too, of course. But what is the strongest and most compelling evidence that you can share with the Commission that you will be a reformer because your history shows you're a reformer? Thank you.
Дякую за запитання.
Thank you for the question.
Вважаю себе реформатором.
Yes, I think that I am a reformer.
Як і вже говорила в своєму вступному слові,
And I mentioned in my introductory speech that in 2016,
початок судової реформи,
when the judicial reform was launched and when there was their demand in the society for the selection, in particular selection for the Supreme Court, and there was a public, open public procedure. So I participated in the selection, and it was not that easy because in 2016, that was happening for the first time, and the international observers were there for the first time, and it was also necessary to kind of disclose information about yourself, your personality, your life, your income to the whole society.
і відкрита була для цих реформ.
But I was not afraid and I was open for the reform. And now I'm open for the reform. I want to bring the reform into life. And
Хотілося б, щоб ця судова
I would like our judiciary to really be reformed as soon as possible and to evoke trust in people. We should be staying at the same level with other European countries where the trust of the public in the judiciary is very high. As far as I know, it's up to 80%.
якщо довіра людей буде повернута,
And if public trust in the judiciary is back, that will mean that we will have investment in this country because we will have investment climate that is favorable. The judiciary is not just a separated, isolated element. We are a part of the other systems, of the whole system, of the whole picture of the state. Then the economy will start functioning well, and the well-being of our people will depend on that. And maybe people won't have to go to court because everything will be good.
Let me follow up on the case that my colleague, Judge Zarzeczny, was discussing a few minutes ago. I just need to understand the case a little bit better if I could. Judge, you indicated that there was a video. Can you explain what did that video show, please?
It was audio.
Oh, just audio, I'm sorry. Okay.
Yes, that is the audio record of the open court hearing. It's attached to the materials of the case. And the point is that according to the recommendations of the Council of Judges of Ukraine, we were trying to make the audio record. Our code of civil procedure doesn't have this binding requirement to disclose the information to the public, but we think that it's necessary to have information disclosed to the public. And when the judge doesn't see the grounds for self-recusal, but there is some information that could evoke doubt in the public, we normally have such audio records where you inform that. Well, that's what I did. I disclosed the information that my husband works in Agroprod service in that company, and this company is respondent in the case. And I asked whether the parties would like to announce any recusals. And the claimant said that he would not object, he would not make any recusal, and he didn't think that there were any grounds for recusal.
So just so I understand, you thought that there might be concerns about your involvement in that case, so you discussed it with the Council of Judges. Is that correct?
є рекомендації.
I did not discuss this issue with the Council of Judges, but there are the recommendations and the decision of the Council of Judges related to the wider context, where they recommend that if there are any grounds for, there are no grounds for recusal, but the judge has some personal elements of information that could be regarded as the ones that need to be opened to the public, for the public not to have any doubts concerning this information, then you have to act this way, to have this audio record. Because situations may be different. We are just a small city, not the city where people don't know each other. That's just a small society, so it's sometimes necessary to make those audio records to disclose the information, to avoid any doubts. And sometimes the parties don't know some personal information of the judge, and in some cases you may disclose this information in the audio record for the parties to be sure that the case hearing will be really impartial. But if the claimant had some doubts as to whether I could really be impartial, he would have announced a recusal, and I would not be hearing the case.
Okay, so more accurately, you were aware that there might be some problems in this case. You looked to the rules that were applicable, to the guidance that had been provided to you, and you made an audio statement concerning the relationship between the case and yourself. Is that correct?
Yes, and let me still specify
Це не просто аудіозапис.
that was not just the audio record, that was the audio record within the court hearing. I mean that the court hearing was recorded in full. And before this court hearing, at the very beginning of it, I just announced this information. I disclosed this information after I announced the composition of the court panel. That's when I informed the party about this case. And then the case hearing went on, and you can see all this in the audio record.
And you informed the side that was not agro-pro, the other party, you informed that you had a relationship with some...
Це судове засідання. Це судове засідання.
In the court hearing, two parties are present, so I informed both of the parties. I explained to all the parties and to the public.
I understand both parties are present. I'm just trying to clarify. In the court, with both parties present, you informed the side that was not agri-pro and the side that was agri-pro that you had a relationship with somebody who was at agri-pro. Is that correct?
Правильно, що вона працює.
Yes, yes. I informed that this person, a relative of mine, is working in Agropro service. Because, you know, even a representative of Agropro service didn't know that I'm the wife of one of their employees, because this is a very large company. That's why I informed this, yes.
I'm not trying to be difficult. I'm just trying to understand specifically what happened. And did you specifically ask the side that was not agri-pro whether they had any objections to your continued participation in the case? Or did they indicate that they were okay with your participation?
Така процедура.
Well, that is a special procedure when we have to explain, to ask whether there are any recusals or self-recusals. And before this, we try to explain what the reasons could be, and then the claimant stands up and says that, for example, there is no recusal in the case, and the respondent also does the same. So it's a clear and fixed procedure. When the court explains the information, provides the rules, and then the parties just stand up and say whether they have recusals or not. That is a fixed procedure for every case. But within this procedure, I disclosed the information about my having something to do with one of the employees.
Let me ask you one more question about the case, Judge Shevchuk. You indicated that if you had known of civil society's concerns, you probably would have recused yourself from that case. What if civil society had had no concerns? Would you have recused yourself from that case? In retrospect, I think Mr. Brookhuizen's question was, what might you do today if you had known everything about the case? And you said, well, if I knew that civil society was going to have a problem, I would probably not have participated. Well, what if civil society didn't have a problem? Would you have still participated?
Дякую за запитання. Просто я хотіла би пояснити дану ситуацію.
Thank you for the question.
Можливо, ще раз.
Well, let me try to explain the situation once again.
Що в підстав
The point is that the ground, as far as the grounds envisaged by Article 36, are not there. I don't see there. I didn't see them, and they were not there. There were no grounds for this, for self-recusal. But what I meant is, maybe I explained it in the wrong way.
має громадськості
In case civil society still could have some doubts,
сумніви громадянського суспільства, тоді я би заявила.
then I would be considered proper to announce, to make self-recusal. I just didn't think about that because according to the law, there is no problem. There are no grounds for my self-recusal in this case. We sometimes talk to judges of trial instances, and you know, sometimes
Вони вважають часом необґрунтовані самовідводи.
judges like to make ungrounded, unreasonable self-recusals, and that's also a problem in the judiciary if too frequently self-recusals, ungrounded self-recusals are made. And the Code of Judicial Ethics, to be more specific, Article 15 says that a judge cannot announce a self-recusal which is not grounded.
Я ж кажу, могла б собі заявити
In this case, I could actually announce 100 self-recusals in 100 cases, but that would be probably the largest number of self-recusals in Ukraine. But since I didn't have any grounded doubts, according to Article 36, I didn't make self-recusal because my husband is just one of the thousands of staff members working there.
вуличної комісії, я
If you still allow me to, I would like to also explain.
Well, can I interrupt you for 1 second? Your Honor, can I interrupt you for 1 second, please? But you did in this case. I don't mean to be difficult, but you did recuse yourself in this case, or you said you would have recused yourself in that case if you had known what civil society would have said. And you still think that that would have been an ungrounded recusal. You just said that it would have been an ungrounded recusal, but if civil society had indicated concerns at the time, you would have recused yourself in a case in which you do not think that you should have recused yourself. Why would you have done that then?
дякую за запитання.
Well, thank you for the question.
Приймаючи рішення
Well,
2000
passing my decision in 2016 and 2017, or sorry, 17, 18, and 19,
не заявляла цей відвід, бо підстав
I
не було.
didn't actually make any self-recusal because there were no grounds for that.
Я не можу чітко сказати, бо
I cannot clearly tell anything about that
я вже напевно, що дала вичерпну відповідь.
because it seems to me that I have given an exhaustive answer and I will just be repeating myself. There were no grounds for recusal, for self-recusal back then. Maybe
Що якщо б громадянське
if
суспільство
civil society has
сумніви,
any doubts,
треба прислухати.
you need to listen to civil society, lend it attentive ear to civil society. That's what my answer would be.
Okay, I appreciate it. Thank you very much, Judge, and let me pass you on to my colleague, Judge Mizentsev.
Thank you, Stephen. Доброго дня, пані Галино. Моє прізвище Мізинцев.
Thank you, Stephen. Good morning, Halyna. I'm Yevhen Mezentsev. You know, sometimes, or rather frequently, it's me who has the honor and pleasure to discuss a controversial issue. I mean, to ask candidates about their property. We have given you some inquiries. You have provided explanations through confirmation of the data with documents. And for the purposes of this competition, we consider it to be necessary to discuss property issues of candidates in the public, to avoid any secrets and to dispel the doubts that the public may possibly have.
Перше питання, з якого хотів зупинитися, це те, що
The issue I would like to focus on is that in your declaration for 2020, you mentioned that your husband's income from Agropro service, already a notorious company for us, was 64,000 hryvnias and something, and 76,000 of insurance payments. According to the tax data, your husband got almost 14,000 hryvnias from Agropro service. What kind of benefit was this, and why was it not included into the declaration of 2020? Thank you for the question. When I was filling out the declaration
За 2020 рік
for 2020,
моїм
My husband
сервісу від 5.03
provided the certificate from March 2020, where the total income indicated was 46,000 and something, and it was sealed. So that's why I reflected this amount of money in the declaration. When I got the inquiry from the selection commission saying that according to the data, I don't have about 13 or 14,000 indicated in this declaration, my husband addressed the Agroprom service asking what kind of amount it was. And he was given us the certificate, which indicates that under Code 126, the tax inspection has, there is some additional benefits like compensation for their trip to the sanatorium, a voucher for sanatorium, and the agro company somehow by mistake did not indicate this amount. That's why the income of my husband, amounting to almost 14,000 hryvnias, was not reflected in the 2020 declaration
з тим, що вони дали не
because the certificate was containing the wrong data. Did you try to address the NACP with the request asking to change the data? Well,
внесення вже був пропущений термін.
the term had already expired. Yes, but you could have asked about this. I have not done this, but I will. I know that you cannot actually introduce changes into the declaration after the term has expired,
Ну,
but
власне, не тільки для
still.
всіх кандидатів
Well,
така порада
the
від
request
людини,
and the recommendation for you and for all candidates would be that after the end of the year, take the certificate from the tax inspection. You have all your income recorded there, and the tax inspection determines all this rather clearly. In 2021, you mentioned a $500,000 gift, and you said that this was the gift to your daughter for the acquisition of some property. Please tell us, after you made this gift, did you submit any application about significant changes in your property situation? Yes, I did.
У вас
Okay, and here is another question. In your declaration,
за думкою
according to our analysts, you don't have the apartment and the land plot that has been inherited by your husband recently. So taking into account the fact that the inheritance came into effect on the 2nd of September, please indicate why it was not included into the declaration, and when did you register ownership of this inheritance item, or your husband, when did he do this?
Дякую за запитання.
Thank you for the question.
Мій чоловік отримав спадщину
My husband
після
got inherited some property under the will. No, it's clear, but just mention to us when you actually registered this ownership for us to understand when you were supposed to include it into the declaration. The inheritance was opened by the notary on the 2nd of September. It was actually on the 29th of August 2021, and on the 2nd and of the 9th of September of 2021, the inheritance case was launched. On the 19th of February 2024, 23, I guess, the period, the 6 months period for acceptance of inherited property will expire. And on the 23rd of February 2022, my husband got all the documents, and under one of the articles, he got the certificate that was to be provided after the expiry of the 6-year term. This was really in 2022. And on the 6th of February 2022, my husband in Ternopil submitted the tax declaration on his property, including this inherited property. Just a moment. So haven't you been yet fulfilling the declaration, the income declaration for 2022? Okay, so please don't forget to include this data into it. Okay, and here is another issue. Several society organizations have pointed it out that in 2014, in the paper declaration, while indicating your income, you indicated the amount of 24,802 hryvnias and some kopics. According to the NABU certificate, your income over that year was 248 thousand hryvnias. So what about this mistake? Thank you for the question. Well, really, while filling the declaration in 2014, I made a technical mistake. My total income was 248,002 hryvnias 80 kopics. And while reflecting this amount of income, I made a mistake. I reflected it as follows, not to be mistaken in filling out, because these were paid by documents. I wrote 248,02,80, which means that I actually omitted their one figure, 0. And this led to problems and differences in the declaration. I've already provided explanations, and I provided those explanations at the selection process in 2014 when I was having qualification assessment. And well, this is a technical mistake that does not show that I'm not diligent and scrupulous. It's clear. And here is another question about your vision of the development of the judiciary. We have told a number of times that you have the longest judicial record, probably as the candidate of this selection, and you started your career right after Ukraine gained independence, which means that you have covered all the paths of working with documents, starting with paper protocols and printing on typewriters, up to electronic court receipt system, total recording, and with video records, and I hope that we will also have remote court hearings. So there has been some rapid development in terms of technologies. Is it not kind of discouraging and discomfortable for you to be facing all those changes in the procedural support of the process? Are you quick in, are you flexible in adjusting to changes, to using technical means, to this openness? Is it okay for you, or is it a problem for you? Probably you need to be adjusting for a period of time to such things. Thank you for the question. These are very positive changes, and I am quick in adjusting to them. Most judges, in particular young judges, don't even understand what it was like to work in the 90s, when every court decision, as you mentioned, was to be written manually. That really was time-consuming, and every mistake you made in the court decision led to the situation when you had to rewrite it, to rewrite the whole page. That really took a lot of time. Protocols of court hearings were on paper carriers, and we also had to check those protocols of court hearings because the secretaries were normally some school leavers. And of course, those technological changes, all this dynamics is highly useful. This helps people access justice. This helps them participate in court hearings. There are video conferencing options, and there may be records made of the court hearings for the party to get acquainted with the protocol, and you don't have to read it, to read the protocols out. Court decisions produced on using computers, I mean technical means,
доступ до законодавства.
access to justice. Yes, thank you, Halyna. You don't have to explain such things. We are your colleagues and we know the way it happens. But just, is it easy for you to get adjusted to this or not? Or you still have to kind of learn anew? I don't have to learn anew. I just learn and I keep up with the times and I try to use all the novelties that appear and that can be used in court and in life. Thank you, Halyna. Thank you for your answer. And then let me give the floor to our chairperson.
Пані Галина, в мотиваційному листі ви
Halyna,
зазначили,
so in your motivational letter, you've mentioned that the judiciary needs to be restarted with a new approach being used within the judiciary. What do you mean by that? Thank you for the question.
Я вважаю, що, звичайно, вся судова система потребує
I believe that the judiciary needs to be restarted. I meant that in the general sense.
найперше це оптимізація.
First of all, we need to optimize the courts.
Я вже зазначала в своєму мотиваційному листі.
This is something that I've mentioned in my motivational letter. We need to do that according to our territorial division. So we have to have bigger courts,
От зараз Тернопільський
courts that correspond to bigger jurisdictions.
військовий дій.
Of course, this is something that we cannot be deciding upon during martial law, and the courts operate as they operated before the law. But having this kind of approach will ensure a better access to justice. We will have a more even workload within courts.
Це буде дотримання розумних строків розгляду справ.
Then we will have normal procedural terms because of this even workload. And we can also have specialized courts, because when we have some small courts where one or two judges are working, it's impossible to have some kind of specialization. And of course, this impacts the quality. Thank you for giving us the context. I now understand what you meant by restarting. Can I add another comment, please? No, thank you. That's enough. You've answered my question. What do you mean by a new approach to the judiciary?
Новий підхід до судочинства, можливо, я виразилася.
A new approach to the judiciary. Perhaps what I meant. Could you please give us the context?
Судочинства. Я мала на увазі все-таки
When I was writing about a new approach, I meant
сказати таких технологій.
the introduction of new technologies, like having remote court hearings under martial law, under quarantine.
Зараз, коли іде війна,
Now that we are having the war, access to justice has been limited because we are often having air raid alerts. The court hearings are being interrupted for that reason. And we have to postpone the hearings. And if we had this opportunity to have the hearings in a remote way, it would make the access to justice
Зрозуміло, дякую.
more available.
Скажіть, будь ласка, особисто ви
Could you please tell us, you personally, as a potential member of HQCJ,
давали перевагу
would you prefer
кандидатам в судді з досвідом?
selecting candidate judges or judges who already have the experience,
Молодим суддям,
or
які там
would
мають цього
you
досвіду
give
набрати?
preference to young judges who still need to gain the experience? So,
От ви особисто
what
чому
would you
б не
prefer, young age or experience?
з точки зору кандидатів?
If we are talking about candidate judges, let me specify.
Які кандидати, які судді потрібні
So what
нашій
kind of
державі?
judges does
Такі
Ukraine need?
молоді, енергійні, але
Young,
ще, які,
energetic,
можливо, не дуже розуміють
but
всіх
those who
нюансів, там,
maybe
та
don't have a
тонкощів,
clear
або вже
understanding of
такі,
all the
якби,
nuances,
досвідчені,
but
які
or
бачили, там,
on the other hand, do we
як це
need
все
more
відбувається,
experienced
працювали там в
judges
різних
who are
інстанціях.
familiar with the procedures, who've worked within different courts or with different courts?
Повинно бути за можливості, звичайно. Це, по-перше, таких от, я би все-таки називала
Well, I would still give preference to people who have integrity, who have the required level of knowledge. Experience and young age must be somehow balanced.
корисно в судовій системі, щоб молоді люди
It's good for us to have young judges working within the judiciary, judges with a new vision, with new ideas, and at the same time, it's good to have people who already have a vast experience, and as a result, we would have a better judiciary. Thank you. So I'm for the balance. Thank you. Oh, ideally, that would be the case. Thank you.
Галина, за ваші відповіді. Чи
Thank
будуть
you,
ще запитання
Halyna, for your
щодо
answers. Do we have any additional questions to our candidate?
Пані Галина, наша співбесіда добігає кінця.
Halyna, your interview is coming to an end. Could you please summarize
На
it?
чомусь ви хочете зосередити увагу ще, можливо,
You can
щось
draw
ви не
our
сказали.
attention to some
Будь ласка,
important
вам слово.
things or add something.
хочу подякувати членам конкурсної комісії за можливість.
I would like to thank the commissioners for the ability to participate in this election. I'm grateful to all the soldiers who are now defending Ukraine. I'm sure that Ukraine will win. And we will also win in the fight against corruption. We will create a new kind of judiciary and become a member of the EU. Thank you.
Дякуємо вам, пані Галина.
Thank you, Halyna.
Співбесіда завершена.
With this, your interview has come to an end. Thank you for participation. All the best to you. Take care and goodbye. Goodbye. Thank you.